regards for you to ask whatever they want?
Yes, Your Honor.
Further, if you are put on probation, you ever violate any of the conditions of your supervision, we'll have a hearing here in court to see if you're what's called a probation violator. If it's determined that you are, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I sent you to prison, again, it could be up to possibly 54 months in prison. You understand that?
Yes, I do.
Lastly, when we do come back here for sentencing, you're going to have the right on that day to say anything you want. Anything you'd like me to know or consider. Your lawyer can speak on your behalf. She can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, I do.
Now, do you understand that whatever anyone says at the time of sentencing regarding what they think the sentence should be, it is just what I characterize it as. It's a recommendation, and I'm not obligated to follow that. Even if they agree, I don't have to go along with that if I don't think that's the right thing to do. Do you understand that?
Yes.
Now, going back to the being eligible for probation, as I mentioned, you are eligible for probation with this count. But there is a presumption that a prison sentence be imposed in this case in regards to the theft of a gun charge, which means it's presumed that the court, any court, would have to impose a prison sentence in this case unless certain findings could be made that would overcome or override that presumption and permit the court to place you on community control sanctions. Do you understand that?
Yes, I do.
Okay. All right, well, do you understand all the possible penalties you face by pleading guilty here?
Yes, Your Honor.
You understand all the potential consequences?
Yes.
You still want to plead guilty?
Yes, I do.
Have you had enough time to talk about this case with your lawyer and have her review the report with you, discuss the issues, and answer your questions?
Yes.
Are you satisfied with the advice and counsel of your attorney?
Yes, I am.
Has your attorney, or has anyone for that matter, made you any promises in regards to what's going to happen at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No, I have not.
Are you entering the plea freely and voluntarily?
Yes.
All right, then. Do you have any questions for me at this time regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No.
Need any more time to talk with your lawyer before we go forward with the plea?
No, I don't.
All right, then what we're going to do at this time is the prosecutor here is going to explain for me what she believes the evidence would show if we did have a trial. I want you to listen to her because I'll have some follow-up questions for you, all right?
Yes.
Okay, Ms. Alessi?
Thank you, Your Honor. At the time this offense was committed, the defendant was in a relationship with Samantha Meadows and living at the residence of James Giles, who also lives there with his other son, David Meadows, and that's in Mentor Lake County, state of Ohio. And on or between February 1st, 2023 and March 26th of 2023, the defendant stole $1,800 that was kept in a dresser drawer from Mr. Giles, who was 80 years old at the time of the offense. And he also stole 3 firearms, 2 of them belonging to Mr. Giles and 1 belonging to Mr. Meadows that was gifted to his sister, Samantha Meadows, that he subsequently pawned at Gold Star Pawn in East Lake. That property was taken without the consent of the owners. During a controlled call conducted by Samantha Meadows, as well as an interview conducted by the Mentor Police Department detectives, the defendant admitted to stealing the guns and the cash, as well as several electronics belonging to Samantha Meadows in order to support his drug habit. The firearms were recovered from the pawn shop, but the victims did have to pay to get those items back, and none of the electronics were recovered or the cash.
None of the electronics, you said?
That's correct. And the cash also was not recovered. Thank you.
Mr. Volpe, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes, I was.
What, if anything, good to say about those facts that she just presented them? Are they true? Did you do what she said?
Yes, I did.
Very well, then. Regarding count 1, charging with grand theft of a firearm, felony of the 3rd degree, what is your plea to that count?
I plead guilty, Your Honor.
You can be seated. In regards to count 2, charging you with theft of an elderly person, felony of the 4th degree, what is your plea to that count?
Guilty.
All right, I have in my possession here a document, it's a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just gone before I can accept your plea, I need to be assured you understand what's in this document and you sign it here in open court. My understanding is that before I came out here, you had a chance to go over this with your lawyer. Is that correct?
Yes.
I'm going to hand this back to you at this time for two reasons. One, I want you to initial the change I made on the second page regarding the mandatory consecutive sentence. And then two, you forgot to sign it, Ms.
Oh,
Springer.
I'm sorry, Your Honor.
So actually have them initial both spots. The fine was changed as well on it right there, so we'll have it cleared up. So if you could show him, go over that with him, Ms. Springer.
Thank you, Your Honor. Okay, go ahead and put your initials right there.
All right. So again, Ms. Springer, you read this to your client and reviewed it with him?
Yes, I did.
Did he indicate an understanding of it to you when you did that?
Yes, Your Honor.
Is that correct, Mr. Volpe?
Yes.
Do you have any questions for me about what the document says and the changes that were made, anything?
No.
You understand it?
Yes, I did.
It appears that you did sign this document on the third page. Did you in fact sign it?
Yes, I did.
You witnessed that, Ms. Springer?
Yes, I did, Your
And
Honor.
Ms. Saleshi?
Yes, Your Honor.
All right, then at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant doesn't understand the nature of the charges, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, grand theft involving a firearm, a felony of third degree, in violation of 2913.02A1, as well as count 2, theft from an elderly person, also this one a felony of fourth degree, but also in violation of 2913.02A1. I will defer sentencing, order a pre-sentence report and investigation, a drug and alcohol evaluation, as well as a victim impact statement. I will continue bond at $10,000, cash surety, or 10%.
Maybe heard on bond.
Sure.
There was actually a couple kind of inconsistent bond figures coming out of municipal court. First, it was set at $100,000 cash surety, 10%. It looks like at the time of the preliminary, it was reset to $75,000 cash surety, 10%. And then there's another entry from the 13th as well on the date of the preliminary, modifying it to $25,000 cash surety or 10%. It does appear that the defendant had posted the $10,000, and which would be reflected from the $100,000 cash surety 10% bond. But I just wanted to bring that to the court's attention.
My intention is to continue the bond that was posted. So I see, let's say on the 19th they receipted $10,000, but in the first entry it says bond was $10,000. Let me look at the bind over. How much money was put up?
I think $10,000.
Maybe they posted it before the bond was amended to 75. It's the same day. Maybe that's how that happened. I suspect the clerk's office just forgot to put another zero in the process. Where it says 10,000?
Yeah, posted on 4th. I'm looking at the municipal docket, but on that docket as well, it says $10,085
No, that's what was
paid.
paid.
Yeah.
Right. But it says $100,000 cash surety 10%.
Is that the bond amount you wanted to continue then?
Yeah, that's
Okay.
what was paid. If that was posted, that's what we'll continue that.
And then,
Hang on, let me just see one thing. In the docket entry in the Lake County docket where it says. All right, go ahead. What were you going to say?
there's a no contact order as well, as a condition of bond through municipal court. The victim, Samantha Meadows, is asking to modify the no contact order just so that there can be some communication, whether that be through the Mentor Police Department or another third party, because there is a vehicle loan out in her name the vehicle is in the defendant's possession. I believe his mother is currently driving it. She would like to get the necessary paperwork signed to get the vehicle loan out of her name, because I don't believe payments have been being made and it's affecting her credit. She was afraid the car is going to get repossessed. So she's looking to modify bond to facilitate some sort of contact with the defendant to get the necessary paperwork signed.
I'm not modifying the no contact order at this point. I'm not doing that at this point. There's a no contact order in place also. All right, Mr. Volpe, so what all this means at this point, as far as bond goes, I've continued your bond at $100,000 cash surety, 10%. You already posted it, so there's nothing more you need to do, except to continue complying with the conditions of your bond. One of those conditions being that you do not use any drugs while you're on bond. You have to submit random urine screens if requested. If those screens should come back positive, your bond will be revoked and a warrant will be issued for your arrest. You understand that?
Yes, I do.
So you're going to need to leave here right now and go right over to the probation department to meet with them, sign some initial papers, and get a date to come back for your interviews with the doctor as well as the probation department. So make sure you go there right from here to get that set up, and then make sure you show up when you're supposed to for those interviews. Because if they can't have the interview with you, they can't complete a report. Without a report, the law doesn't even allow me to consider probation as an option. I won't be able to do that. You understand that?
Yeah.
All right. Is there anything else for the record, Ms. Aleshi?
No, Your Honor. Thank you.
Ms.
versus Anthony Jones, case 23 CR 203. Defendant is in court, represented by counsel Tim Deeb. The defendant was previously indicted in a 5-count indictment issued on April 11th of 2023 and entered a plea of not guilty. After engaging in plea negotiations with defense counsel, it is my understanding today the defendant is going to withdraw that previously entered plea of not guilty and plead guilty to an amended count 1, attempted felonious assault, a felony of the 3rd degree, with the attached 3-year firearm specification in violation of 2941.145, as well as the attached forfeiture specification, and also plead guilty to count 3, having weapons while under disability, a felony of the 3rd degree. In regards to sentencing, the state has agreed to cap our sentencing recommendation at 5 years. Prior to making this offer, the state did confer with the victim in this case. He approved the offer, and he was notified of today's hearing. Thank
So
you.
when you say 5 years, just to make sure we're on the same page, a total of 5 years, which includes the firearm specification?
Yes, Your Honor.
Mr. D, does that accurately reflect the discussions you've had with the prosecutor here?
Yes, they do, Your Honor.
And Mr. Jones, were you able to hear what was said by the prosecutor and acknowledged by your lawyer here in regards to what they believe your plans are here today?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty to 2 of the charges here and plead guilty to 2 charges. One of them's been reduced, and I'll go over that with you here in a minute to make sure you understand what the charges are. The other charges would be dismissed pursuant to the agreement. We would then defer sentencing to get some evaluations completed, come back on a later day for sentencing, where it's been represented by the state that they will recommend no more than an overall total of 5 years in prison. You're free to recommend to the court whatever sentence you believe is the appropriate lawful sentence to impose. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today?
Yes, sir.
Well, before I can accept your guilty plea, then I need to make sure you understand everything we're doing here. I need to make sure you understand what you're charged with in pleading guilty to, the rights you have and the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you need a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Let's get started then. How old are you, Mr. Jones?
25?
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
Nothing.
On the form here, I was talking about the sentence, the maximum sentence. The maximum prison term would be 3 years and 72 months.
Combined, just because the firearm specification is quantified in the terms of years.
But then it says total of 6 years.
That part is incorrect, Your Honor. It should be a total of 9 years.
Right, all right.
I went over that with my client, Your Honor, and we do know that it's 9 years.
Well, then why
We
would you
thought
say
that
something
in
on the
parentheses,
form?
no, in the parentheses, we thought that was describing the 72 months,
Okay,
just to
gotcha.
clarify that. But we did know that the total was 9.
Okay.
Thank you, Your Honor. I apologize.
Where did I leave off? I forget where I left off. Do you know?
We asked him if he understood everything that he read?
I haven't even read the indictment yet, have I?
No. Yes, he did.
Yeah, I asked about that.
I think that's actually right after
All
that.
right, so we're on the indictment now. All right. So, may have asked this. Are you an American citizen? Make sure.
Yes, you asked it already.
Now, you would have received a copy of the indictment in this case. It looks like you would have gotten it back about a month or so ago. The document that sets forth what the charges are. Do you remember getting that?
Yes.
At some point, you had a chance to look that over.
Mm-hmm.
Now, in that indictment, there are 5 counts. You're pleading guilty to charges in regards to 2 of these counts. So I'm going to go over those with you right now. In count 1, what is alleged here, and this isn't what you're pleading guilty to, but what you're charged with, is on or about February 13th, 2023 in Painesville Lake County, Ohio. It's alleged that you did knowingly cause or attempt to cause physical harm to Brendan Anderson by means of a deadly weapon or dangerous ordinance, specifically a Colt 38 special revolver. That conduct constitutes the offense of felonious assault. It's a felony of the 2nd degree. Do you understand what you're charged with in count 1? Again, this is not what you're pleading guilty to, but that's what you're charged with.
Yes.
Any questions about it?
No.
Now, for purposes of the plea today, the state has agreed to amend count 1 to what's called attempted felonious assault. And what that means is that you engaged in conduct that, if you were successful, would have resulted in the offense of felonious assault. And the significance of that is that it reduces it from a felony of the 2nd degree to a felony of the 3rd degree, which is a big difference in terms of potential penalties that you could face. With the felony of the 2nd degree, you can be sentenced anywhere. The maximum would be an indefinite sentence of 8 to 12 years in prison. With the felony of the 3rd degree, the maximum sentence is 3 years, 36 months. So do you understand the difference between the two?
Kind of, yeah.
Do you have any questions about it?
So that's not, would you say 9 to 12? That's not involved?
That's not involved. I said 8 to 12.
8 to 12.
So with the felonious assault, with the charge, it was going to, if you were convicted of that charge, it would be an indefinite sentence of anywhere, the minimum portion would be anywhere between 2 to 8, and the maximum would be, you basically take half of the minimum and add it to that. So, for example, if I gave you 6 years, if it was 6 years in the minimum, it would be 6 to 9 years, but it could be ultimately 8 to 12 years. With what you're pleading guilty to, there's no indefinite sentence. The penalty can just be anywhere from 9, 12, 18, 24, 30, or 36 months. So the maximum would be 36 months, but it wouldn't be indefinite either. It would be a definite sentence. I can't do an indefinite sentence with what you're pleading guilty to. And the maximum is I can't go more than 3 years with that one count. Do you understand that?
Understood.
Any other questions?
No, sir.
So do you understand then what you're pleading guilty to in regards to the attempted felonious assault?
Yes.
Now, this charge also carries with it what we call firearm specification and alleges that you had a firearm on or about your person or under your control while you committed the offense, and that you either displayed the firearm, brandished the firearm, indicated you possessed it, or used it to facilitate the offense. Do you understand what's alleged in that specification?
Yes.
Any questions about that?
No.
There also is what we call a forfeiture specification, which alleges that during the commission of the offense, you had in your possession a Colt 38 special revolver and ammunition, which were used as instrumentalities to commit or facilitate the commission of the offense of felonious assault. Whole point of this is that you just forfeit any right you have to have that property returned to you at the time of sentencing. You understand that?
Yes, I do.
All right, then in count 3 is the other charge you're pleading guilty to. What's alleged here and what you'll be admitting to is on or about February 13th, 2023 in Painesville Lake County, Ohio, that you, not having been relieved from disability in their operation of law by legal process, knowingly acquired, had, carried, or used a firearm or dangerous ordinance, and that you at the time were a fugitive from justice, which makes the offense having weapons while under disability a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in regards to this count?
Yes, Your Honor.
Any questions about it?
No.
Now, there are 3 other counts in this indictment. Those are all being dismissed pursuant to the agreement. Is that your understanding?
Yes, it is.
Any questions about any of those 3 charges?
None whatsoever.
Well, then before Before I can accept your guilty plea to the charges I just read to you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, do have the right to have a trial in this case. Now, a trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty of the charges. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence that either side wanted to present. Those 12 jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision, which means all 12 of the jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, I do.
You understand by pleading guilty, you're giving up your right to have a trial?
Yes, I do.
Now, if we did have a trial, you would have the right to have an attorney represent you at the trial. If you could not afford an attorney, the court would appoint one for you free of charge to represent you at trial. Do you understand that?
Yes, I do.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Now, by her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You are presumed innocent of the charges, and the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes, I do.
Now, when I speak of this burden of proof, since it's a criminal case we're dealing with, the burden of proof is what we refer to as proof beyond a reasonable doubt. That's the highest burden there is in our justice system, and what it means, it's the amount of the evidence and the quality of the evidence the state has presented at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the criminal offenses beyond any reasonable doubt before you could ever be found guilty. Do you understand that?
Yes, I do.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to try to do that, if we did have a trial, the prosecutors would bring witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. So we could ask him anything he wanted to within certain rules. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial, you can call your own witnesses to come to court and testify for you if you wanted to and answer your lawyer's questions. Now, you're not required to do that, but you have the right to do that if you wanted. Do you understand that?
Yes, I do.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come into court and testify for you and answer your lawyer's questions if that person wasn't willing to come in voluntarily on their own. Do you understand that?
Yes, I do.
Now, you also have the right at a trial. Mr. Jones, you could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify against yourself if you didn't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's solely your choice, what that really ultimately means is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, she would not be allowed to call you as a witness and make you get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further, if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that's above me. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. The court will enter if your plea is accepted, as well as any other issues you could have raised or brought up to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed here? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
None whatsoever.
Do you understand them all?
Yes, I do.
Do you still want to plead guilty?
Yeah.
Do you understand a guilty plea is a complete admission of guilt? So it means you're admitting to the facts being alleged by the prosecutor regarding the two charges we went over that you're pleading to. We're not going to deal with later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of the plea is you'll be found guilty by the court and you'll subsequently be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, I touched upon this a little bit earlier in regards to count one, but I'll go over them in more detail here now. This is the attempted felonious assault, the reduced charge. This reduced charge is punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or increments in between of either 12, 18, 24, 30. So if I had to select a prison term for this count, it'd be 9, 12, 18, 24, 30, or 36 months, and that'd be the number of months you'd have to serve in prison for that count. Do you understand that?
Yes, I do.
Now, this count also carries with it a firearm specification. This firearm specification requires that the court impose a mandatory prison sentence of 3 years, which must be served prior to and consecutive to any other prison term that I impose in this case. Do you understand that?
Yes, Your Honor.
The other charge you're pleading guilty to is count 3. That's the weapons under disability charge. That carries with it the same range I mentioned for the attempted felonious assault: 9, 12, 18, 24, 30, or 36 months. Do you understand that?
Yes, I do.
Now, in this case, since the mandatory prison sentence is required to be imposed in the firearms spec, a prison term will have to be imposed on these charges. And as the judge, I do have discretion to run the prison terms imposed on counts 1, I should say the lesser offense of count 1, and count 3 concurrent or consecutive. Again, the firearm specification must be consecutive to the other charges, which means it has to be served prior to, before you even begin serving the other sentence. You'll serve the 3 years, then you'd begin serving the prison term on the other counts. You understand that?
Yes, Your Honor.
Now, in regards to the other 2 counts, though, I do have the discretion to run those sentences either concurrent or consecutive to each other. Concurrent means you'd serve those together at the same time, whereas consecutive means one after the other. You'd serve the prison term for the felonious assault, the attempted felonious assault, complete that, then serve whatever the prison term was on the disability charge. You understand the difference there?
Yes.
So with this particular case, and I'm required to make sure you understand the maximum possible penalty you face, the maximum possible penalty you face, if I gave you the maximum sentence on each count and ran them consecutive to each other as well as consecutive to the firearm specification, would be 9 years in prison. Do you understand that?
Yes.
Now, are you currently on probation or parole to any other courts or agencies?
I believe probation.
Where would that be?
Lake County.
To the county or to the...
No, Your Honor, he is not, he was on probation to Painesville Municipal Court before. I believe he was off at the time of this offense. However, he was under supervision, hence the weapons under disability, because he was on a payment plan and he was required to appear in Erie or Allegheny County for a criminal mischief charge, hence the warrant that caused the disability.
Well, the other charges that you have pending, are they felonies or misdemeanors?
Can you elaborate?
He doesn't have any pending charges.
Oh,
It was
I
resolved.
thought
But
you
he was,
said you did something in Allegheny.
it
or-
was resolved, and he was on a payment plan. And he was supposed to appear every time.
Oh, so there's no pending charges.
No, but since he didn't appear for a hearing, that's when they issued the warrant, and that warrant had been outstanding. So I
remember.
believe he's technically on supervision there
Okay. So you're on to a court in Pennsylvania.
for misdemeanor.
Okay.
What would be accompanying a misdemeanor
Okay.
in Ohio?
All right. The only reason I asked that, Mr. Jones, is that if you're on probation to another court at the time you commit a new crime, there could be consequences with that court for committing a new offense while on probation. Nothing I'm going to do about it, or I have the authority to do about it at sentencing, but there could be consequences in that court. Do you understand that?
Yes.
I have no control over that. I just need to make sure you understand that it would be a violation of your probation if you commit a new crime while you're on probation to another court. Do you understand that?
I do not.
Any questions about that?
No, I don't.
In this particular case, a prison term, again, is mandatory because of the firearm specification. And upon your release from prison, you would be placed on what we call post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you served and completed the prison sentence. And in this case, it would be for at least 1 year, and it could be up to 3 years. Do you understand that?
Yes.
And while on post-release control, if you ever violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, I do.
Now, in addition to the prison terms I just mentioned to you, there's other sanctions that could be ordered. You could be fined in this case. Each of the 2 counts that you're pleading guilty to carry with it a possible term in prison, a possible fine of up to $10,000. So together is a possible fine that can be imposed of up to $20,000. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay court costs or reimburse the county for any costs of confinement, community supervision, or treatment if any that were applicable. Do you understand that?
Yes, Your Honor.
There's also, the court could order restitution to the victim for any economic loss any victim may have suffered as a direct result of the conduct involved. Do you understand that?
Yes, Your Honor.
And lastly, I talked about that forfeiture specification regarding the gun. At the time of sentencing, any right, title, or interest you have in the gun as well as the ammunition would be forfeited to the state of Ohio. Do you understand that?
Yes, Your Honor.
All right, now a few moments ago I explained the prison terms that were involved here, and I told you there was a mandatory prison term that was required to be imposed on the firearm specification. So as a result, at the time of sentencing, I will not be able to put you on community control sanctions. You understand that?
You're not eligible for probation.
Yes, Your Honor.
Now, while you're not eligible for probation, you would be eligible for judicial release. Judicial release is a motion that you could file with the court, with me, assuming I'm still sitting here at the time, if not, whoever's sitting here, requesting to be released from your prison sentence early and placed on probation. Now, you would be eligible for that after you've served the 3 years for the firearm specification. So the 3 years is a mandatory term. You have to serve that, and you have to serve the full 3 years. But once you serve that, at some point, depending on what other prison sentence is imposed, you would be eligible to request judicial release. You understand that?
Yes, Your Honor.
Not just because you're eligible doesn't mean it's automatically going to be granted, but you would be eligible after serving a certain amount of time after you finish the mandatory prison term for the firearm specification. Any questions about that?
No, Your Honor.
Did I explain what judicial release was? Judicial release is basically being put on probation, being released from prison and being put on probation to the court for a period of time. That's what judicial release is.
But it's not a yes or a no.
It's not automatic. When you're eligible, you'd have to file a motion with the court, and then it'd be up for the judge to decide whether me or whoever the judge is at the time would grant that. And if it's granted, then you'd be on probation to the Lake County Probation Department for a certain amount of time, could be up to 5 years, with certain conditions that you'd have to follow for the period of time while on probation. But again, it's not automatic. You're not automatically. It's not automatically granted. You're eligible for it after you serve them a certain amount of time after you finish the firearm specification, but that's up to the judge to decide whether he or she would want to grant it. You understand that?
Yes.
Any other questions about it?
No, Your Honor.
Lastly, when we do proceed to the sentencing hearing, in this case, you're going to have the right on that day to say anything you want, anything you'd like me to know or consider. Your attorney's allowed to speak on your behalf. He's allowed to recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Now, do you understand that whatever the attorneys have to say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not obligated to follow that if I don't think it's the right thing to do. Do you understand that?
Yes, Your Honor.
All right. Well, do you have any questions at all then regarding the potential penalties you face by pleading guilty?
None whatsoever.
You understand all the possible consequences?
Yes.
And you still want to plead guilty?
Yes.
Have you had enough time in this case to talk about the matter with your lawyer and have him review the reports with you, discuss whatever issues there may be, and to answer your questions?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your attorney?
Yes, Your Honor.
Has he, or has anyone for that matter, made you any promises about what's going to happen at sentencing which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
All right, then. Will you have any questions for me at this time regarding anything we've talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to?
None whatsoever.
Do you need any more time to talk with your lawyer before you enter your plea? That's a no, just for the record. Okay. Very well, then. At this point, what we're going to do is the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to what she has to say because I'm going to have some follow-up questions for you, all right?
Mm-hmm.
Ms. Alessi.
Thank you, Your Honor. If this case proceeded to trial, the state would prove beyond a reasonable doubt that on February 13th of 2023 in Paynesville, Lake County, state of Ohio, the defendant attempted to cause physical harm to Brendan Anderson by means of a deadly weapon. Specifically, while in the KFC parking lot, the defendant used a firearm to fire 2 shots at the victim. The victim was hit 1 time in the left lower abdomen and had to go to the hospital for his injuries. The second round hit the victim's vehicle. After the offense, the defendant hid the gun behind the fence line of KFC and fled from the scene on foot. At the time of the offense, the defendant was a fugitive from justice. He had a pending case in Allegheny County, Pennsylvania for criminal mischief. The defendant had failed to appear at a hearing back on March 24th of 2022, and a warrant was issued for his arrest. About a month prior to this incident, on January 14th of 2023, during a traffic stop by Paynesville Police Department, the defendant was advised in person of that outstanding warrant as well, and on the day of the offense, after committing it, he fled from the scene. Thank you.
Thank you. So, Mr. Jones, were you able to hear what the prosecutor had to say regarding what she believes the evidence in this case would show if we did have a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Say it again.
What, if anything, do you have to say about the facts as she presented them? Are they true? Did you do what she said?
Yes, Your Honor.
Very well, then, regarding the lesser included offense or the reduced charge of count 1 being attempted felonious assault, a felony of the 3rd degree, what is your plea to that count?
Guilty.
In regards to the firearm specification, what is your plea to that?
Guilty.
In regards to that forfeiture specification, what is your plea to that?
Guilty.
As for count 3, charging with having weapons while under disability, a felony of the 3rd degree, what is your plea to that at this time?
Guilty.
All right, I have in my possession at this time a document. It's a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand what's in this document and that you sign it here in open court. Now, my understanding is that before I came out here today, you had a chance to go over this document with your lawyer. Is that correct?
Yes, I did.
Mr. Deeb, is that accurate? Did you read this to your client and review it with him beforehand?
Yes, Your Honor. We went over it in the jail earlier this morning, and then we went over it just briefly here prior to Your Honor coming out.
Is that correct, Mr. Jones?
Yes, Your Honor.
You understand what it says?
Yes.
Any questions for me about it?
No.
It also appears in the bottom of page 3, there's a line that says signature of defendant. It appears to bear your signature. Did you sign that document there?
Yes, I did.
Did you witness that, Mr. Deeb?
Yes, Your Honor. We called in the prosecuting attorney, and I signed it, and then I handed it to her in her presence.
So you witnessed that as well, Ms. Leshy?
That's correct, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights.
If I may, did you make a correction to that 6 or 9?
Yeah, let me give you a few that's what I was looking at, to initial that. I appreciate that. Again, for the record, the original document when it was reviewed said the maximum overall sentence was 6 years. It's actually 9 years. 6 years for the 2 counts, and then there's an additional 3 years for the firearm specification. That's just reflecting what the maximum possible sentence could be. I'm required to make sure you understand that.
Right here, this modification right here.
So it's 9 now?
Well,
No,
it was
that's
9 when I just told you.
When we went over it this morning, when I talked to you, when it said 6 years, we thought that was referring to the 72 for a total of 6, 3 plus the 72, which was a total of 6 for 9. But it's a total of 9 years, given the 3 years plus the 72. You're aware of that, correct? Okay, the judge just clarified.
I just made that change there, so I just want you to initial that.
Initial this right
If
here.
it
that
said
you've been
6,
informed.
then-
You can stand up if you need to. Your Honor, he initialed that and understands that amendment. Thank you.
Thank you. All right, so let the record reflect that the defendant was here in open court with his lawyer advised of all his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charges, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, finding the defendant guilty of the lesser included offense of count 1 being attempted felonious assault, a felony of the 3rd degree in violation of 2923.02 and 2903.11A2, as well as the firearm specification, 3-year firearm specification contained in count 1, and the forfeiture specification. I also find the defendant guilty of count 3, having weapons while under disability, a felony of the 3rd degree in violation of 2923.13A1. All the remaining counts of this indictment will get dismissed pursuant to the agreement between the parties. That'll happen at the time of sentencing. I'm going to defer sentencing, however, order a pre-sentence report investigation and a victim impact statement and bond with all the conditions will be continued. Is there anything else for the record at this time, Ms. Alessi?
No, Your Honor. Thank you.
Mr. Deeb?
If I could have 1 second, Your Honor.